Welcome back for another episode of Uncontested. My name is Rob Johnson, and joining me as always is the man behind the practice, Sean Lohman. Welcome in, sir.
Thank you, Rob. How are you?
Doing well
Good.
today. It got above zero here in Michigan, which is nice.
That's nice.
A nice warm treat for us here. So, Sean, I know there is, obviously there's years of things you can learn when it comes to estate planning. That's why there's practitioners and professionals such as yourself that walk people through that. But I think there are a short list of things that people miss when it comes to their estate plan when they're going through the details of what they ought to put together. So I thought it would be relevant today to discuss 3 things that people miss when it comes to their estate plan.
It depends on who's doing the plan for them. A lot of people try to do budget plans and things like that, or they do plans online, or they go to somebody who just does fill-in-the-blank plans where they take a prior client's name out, stick a new client's name in, charge them a couple $100 and send them on their way. And those plans, 9 out of 10 times, are going to have problems. If you ask me what the biggest problems are that I see that are missed by estate planning attorneys, the first has got to be protecting kids from getting a hold of your assets when they turn 18. So, a lot of people say, well, I've left my life insurance to my spouse and then to my kids. I've left my retirement funds to my spouse and then to my kids. And in my will, I've left everything to my spouse and to my kids. It's great. I mean, everybody has to have a will in place. Everybody needs to have those beneficiary designations in place. But here's the problem. What happens if your spouse is not there to take your assets and everything is left to your kids? If things are left, in a will, you can set up a rudimentary type of protection for your kids until they turn 18. But anything that bypasses the will or the probate process, which would be your life insurance or your retirement plan, those assets are not controlled by your will. And those assets go directly to your children, and they get them on their 18th birthday. And there is nothing that a court can do or that you can do after the fact to prevent that from happening. And I will tell you that I have seen kids' lives ruined over the years by them getting a hold of their inheritance at the age of 18. Some kids are still in high school when they're 18. And you can imagine what that would mean if they got a hold of those assets. So I would say that the number one mistake that people make is not providing protection for their children or their grandchildren in case they were to take when they were minors, and protecting those assets not just up to the age of 18, but beyond, to keep those kids responsible and keep them from ruining their lives with a huge amount of money, or what to them could be a huge amount of money. It may not be a lot of money to us, but $50,000 to a kid is a heck of a lot of money. That'll buy him a really nice car. And so, we see that happen way too often.
Yeah, I would imagine that there's countless cases of that happening where someone hits it big during senior year of high school year, and they're the coolest kid in school for about 3 months, and the cash is gone, and it sets them back. They don't really realize there's value in having plans that have children wait until they're at least 10 to 15 years into adulthood, right?
I saw a kid that inherited $300,000 before he turned 18. He was able to get a hold of that money at the age of 18 when he was still in high school. He then inherited more money when he was in college, and it absolutely ruined his life. And it happens all the time. I saw another kid who got a hold of $100,000, and he was dead within 30 days. Dead. He just, he got into drugs and boom, just killed him. He had nobody to help him. He had nobody to oversee his money. He had nobody to help him understand how, what the impacts of spending money on things like this did to your life. And he was dead within 30 days. So this happens. And it's our responsibility as adults, as their parents, as their grandparents, what have you, to put provisions in place that protect them from themselves. And it is the greatest gift that you can give to somebody. It doesn't mean you think they're irresponsible. It doesn't mean that you think they're going to go out and blow the money. What it does is it provides these guardrails that, lets the kid, learn how to stay within the lines, but it provides somebody to become guardrails that sort of bats them into the line if they start drifting out. And so that's what we are supposed to do as parents. And that is the responsible thing to do to protect your children, to keep them from literally ruining their lives with a great blessing, which is these assets that you have left them. If you can't be there yourself to protect them, at least set up a provision in an estate plan that provides that protection for them.
Well, I would imagine that. Well, hold on. Before I go into that, one question I have, Sean, is I can understand why people that don't have a lot of money or assets might elect not to get an estate plan, because it's still not right. But in their head, they're thinking, well, I have a lot of money anyway. It's not worth spending the money. That's not correct, but I can at least understand that. The people that have $300,000, $400,000, $500,000 that are going to, or more, that are going to go to a kid, what do you think is preventing those people that have the means from putting an estate plan in place? Because to me, that would be like step one. I have a lot of money. Where's it going when I die?
I think people just don't know the risks that are out there, the risks that exist. Do those people have guardians named for their children? If they have a guardian named, surely somebody has spoken to them about, well, these assets that you're leaving them, how are you going to protect those assets for them? And we don't just, we have parents that come in that protect their kids' assets. Even when their kids are 40 and 50 years old, they're setting up, protective trusts for their kids, where their kids are the trustees of their own money. They have control over their own assets, but it provides protection for them, for those kids, against bankruptcy, against creditors, against judgment, against potential ex-spouses. So, we're not just talking about protecting the kids at the age of 18, 19, and 20, 21, 23 years old. We're also talking about protecting these kids all the way into life from real things that can happen to them, whether it's having to declare bankruptcy because they had a business deal that went bad, protecting those assets from the availability of bankruptcy court, to judgment collection, to getting a divorce and ex-spouses making claims against that money. So these protections go on for a long time. I have clients that come in their 30s, your age range, where they'll come in and they'll say, I want to protect my kids' assets. They're 6, 7, 8 years old. But I also have people that come in their 70s, and they're coming in with their children who are in their 40s or 50s, and their children are saying, how can mom protect these assets for me from these outside entities, whether it's a bankruptcy or a creditor that's trying to collect, or potential ex-spouses. So, our job as parents doesn't end when they turn 18. And certainly kids have different needs as they go through life, but we can provide this protection for them from the beginning. So going back to your question, why don't parents do this? Most of the time it's because they don't know they can do this. Most of the time it's because they don't know this protection exists. When I sit through a meeting with a potential client and I walk through the risks that exist and how we can protect the kids, I will tell you how 90% of the time clients look at me and say, why doesn't everyone do this? Why doesn't every person out there do this? And it's just because they don't know, just like those clients sitting there didn't know. And which is why we do things like this. We try to educate people on what is available to them. And in the long run, the cost is minimal in comparison to the protection that it provides for those that you leave behind.
Very good. So what's number 2, Sean?
Number 2, I'm going to have to say, is a power of attorney. Powers of attorney are great, but the legislatures in every state change the laws for power of attorney all the time. So first off is having what we call a durable power of attorney. So what's a durable power of attorney? A durable power of attorney extends beyond the disability of the principal. So the person who's creating the power of attorney, a durable power of attorney extends beyond their incapacity, which makes sense. But not all powers of attorney are durable. So if you don't have the language in there that this power of attorney exists beyond my incapacity or beyond the principal's incapacity, if that language is not in the document, then when you become disabled, because you don't have the power to withdraw the power of attorney at that point, when you become disabled, that power of attorney ceases to exist. It is terminated. So a durable power of attorney is extremely important to have an effect. The other thing is durable powers of attorney, if they were drafted, 3-4 plus years ago, may not have the language in them that you need, because banks are requiring more specific language to buy and sell homes. Closing attorneys are requiring more specific language to be in a power of attorney to close on homes. Banks are requiring, going back to banks, are requiring powers of attorney to do banking for somebody, to use their checking account. I had a manager at a bank in town tell me that in 1 week they had people come in with 5 powers of attorney. The only power of attorney that their legal department allowed to be used was mine. And this was a branch manager of a bank in Louisville, Kentucky. 5 powers of attorney from different lawyers in the course of a week, and my firm's was the only power of attorney that this bank, their legal department, authorized to be used. So, our powers of attorney are long. I've been doing this for 28 years, and I tell people all the time, when I first started doing estate planning, my powers of attorney were 2 pages long. Honestly, 2 pages long. I still see people come in with 2-page powers of attorney, but my powers of attorney now are 14 to 18 pages long, depending upon the powers that we're putting in there. So the detail in a power of attorney have gotten much more significant. If you are getting older, or if you have parents or grandparents that are getting older, you need to make sure that their powers of attorney have the ability to make and fund trusts in them, specifically for the ability to create a trust to avoid Medicaid consideration over their assets. We have clients that will come in, kids, adult children, who are saying, Mom just fell, broke her hip, ended up in a nursing home. How do we protect her assets from Medicaid consideration? They didn't think of doing this before, so they're trying to do a crisis plan, which we can help them with. But our first question is, do they have a power of attorney? Yes. Is the power of attorney durable? Yes. Does the power of attorney permit the creation of an irrevocable trust or a Medicaid asset protection trust? Well, that's where most attorneys stop short in the durable powers of attorney that they create. They say no. Well, guess what? You've taken away about 90% of what I can do to protect those assets for you from Medicaid availability. So we make sure that our powers of attorney have those provisions in there. And then the last thing, you're young. I'm 53. I do estate planning for people in their 20s all the time. People in their 20s, me at the age of 53, even people that are in their 60s, we don't necessarily want people running around with our power of attorney, right? It's risky. It's risky. Even if you're naming a spouse, and if the spouse isn't available, then your parent or a brother or sister or even an adult child, it still makes us a little nervous that somebody could take that they could deal with our business. They could deal with our checking account, our savings account, our investment accounts, everything essentially through a power of attorney. So what we do, and what I recommend people do, is we create springing powers of attorney. In other words, the power of attorney does not spring into effect unless the principal's disability has been certified by a physician and probably a spouse. So sometimes we'll do one physician, sometimes we'll do two physicians, sometimes we'll do a physician and a spouse. It just depends on the person. But most of, yeah.
Sorry, is there a reason that that's not in all power of attorneys, like the springing clause? That way, I mean, to me, that would be logical. Like this, you can't use this unless it's been certified by a doctor and a spouse, or a doctor or whatever.
It is logical, but any online platform is not going to provide for that. And attorneys that dabble in estate planning are not going to know how to draft a springing power of attorney. If you ask them if they do springing powers of attorney, they're going to look at you with a blank stare. So you have to do this type of work. I mean, in order to really know the more advanced ways of getting these documents in place. Everyone should have a power of attorney. Is it risky? Yeah, if you give somebody your power of attorney, they can run out and do what they want. But if it's springing, then that requires anybody who's relying upon that power of attorney to make sure that there is a statement there from a physician that states that you're disabled and incapacitated and cannot make these decisions on your behalf, and either another physician's statement or a spouse's certification that you are disabled or incapacitated and cannot make decisions on your behalf. So that provides that protection that I think is important to have, especially if the principal, the grantor, me or you, is making that power of attorney when they're younger, or when there's no illness in existence or anything like that. So a properly executed durable power of attorney, I would say, is mistake number 2. And then mistake number 3 goes back to arguably the most important part of estate planning, and that is children. Guardianship of minor children and providing for a temporary guardian of your children. You know, most people, well, there's a lot of mistakes that are made in this realm. Number 1 would be only documenting your guardian in your will. Well, a will is only valid if you die. So if something happens to you and you're incapacitated, let's say you're in a severe auto accident and you are on a ventilator and then you're in rehab for months at a time. Well, you may have named a guardian for your children in your will, but your will is not valid unless you're dead. It's a testamentary legal document, which means that it is only valid for when you die. So who becomes the guardian of your children? And that's one thing that we do that I don't know of anybody else that does here in town, and that is we provide for temporary guardians. And we don't document those just in your will. We document those in your power of attorney. We document those decisions in other outside documents, so that if a petition for guardianship is filed in probate court and somebody wants to be named the guardian of your children, you have a legal document that nominates your guardian, your temporary guardian, for you, and makes sure that somebody that you would never want raising your child is not in fact raising your child, because anybody can go to court and petition to be named the guardian of your child. Anybody can go to court and be named your conservator over your funds. So that's what we're trying to do in estate planning, is instead of leaving it up to some judge, some stranger to make these decisions, make these decisions in advance so that you have total control over your funds that will be expended to raise your child and your child, him or herself. So I think those are the three major, those are the three major things, mistakes that I see people make in estate planning.
Well, it's amazing how many levels there are to this. Hearing you talk, people that dabble in estate planning versus people that practice and understand the depths of it to make sure all those contingencies are laid out. When you had mentioned the power of attorney going from 2 pages to 14 to 18 pages, I would imagine that's because there's more contingencies built in. There's more things that are necessary in case of. Is that the case?
Absolutely. It's like the trust provision. Kentucky state law requires you to have within the power of attorney the ability to create and fund trusts spelled out in the document. So that takes up a half a page in our powers of attorney. Now, we don't put it in every power of attorney because a 25-year-old doesn't need that. But we do for every person who's over the age of 65. So, it just depends upon your life stage. Somebody who owns a home in Old Louisville or, in the Highlands in Louisville, we don't put provisions to handle land and farm and things like that. So there's a lot of provisions that one person may need that other people don't need. For us, we're creating documents that are specifically made for the specific client. Nobody's are the same as the person before them. Whereas a lot of attorneys will just take the last person's name out of the document and put the next person's name in. And if you don't have those statutory provisions met within that durable power of attorney, it will be rejected. And there's no worse time than to find out your power of attorney is lacking than when your mom or dad has lost capacity and you take your power of attorney to the bank so that you can do their banking for them, and the banker says, "I'm sorry, but our legal department has rejected that. It doesn't meet the statutory requirements." Or when you're trying to sell their home because they've gone into assisted living and you need to sell their home for whatever reason, either you can't afford to maintain it or you need to convert it to cash for whatever reason. And the closing attorney tells you get through the whole process and the closing attorney says, "Wow, this power of attorney doesn't give you this power. We can't close on this property." So this happens. This is very real. And people think that just because a lawyer drafted the document, it's good. But that's not always the case.
Yeah. One of my favorite recurring bits in television sitcoms is when, usually there's always some type of scuffle between younger people, and one of them is like, well, my dad's an attorney, and the other one is like, your dad's a real estate attorney. Calm down. He doesn't he's not like a criminal defense attorney or,
Yeah.
So all attorneys are not created equally is a very good thing.
That's absolutely correct. Whenever I talk to somebody and they say, "Ooh, I know who to call if I ever get in trouble," I tell them, if you have one phone call, call my law partner. if you have one phone call from jail, call my law partner. He handles the criminal cases.
Yeah, I can set you up with a sweet estate plan while you're behind bars.
Right. Yeah. But that's very true. That's very true. I mean, we all have our niches. We don't, the specialty of law is not certified in Kentucky, but we all have our areas of concentration.
Yeah, it's like physicians. You have surgeons, you have emergency docs, you have gastroenterologists. It's a specialty, and lawyers are no different. You can't specialize in everything.
That's right.
Well, I appreciate it, Sean. So for the listeners, that's 3 things that you absolutely need to pay attention to in your estate plan so you don't overstep them. Anything else before we wrap up today, Sean?
No. I just thank the listeners, and I certainly, if anybody has a question, give us a call. We're more than happy to answer your questions.
Very good. And we'll make sure all of Sean's practice information is in the show notes for today's show. Sean, as always, thank you so much. Listeners, we appreciate you following along, and we will catch you on the next one. Take care.